Rose. I am Yarrow Spitzfaden. I am the Employer Relations Coordinator at Red Rocks Community College in Lakewood, Colorado, working on Colorado's first Department of Labor registered apprenticeship program in cybersecurity. So I'm working on employer engagement to broaden the career opportunities for our students into the field of IT, network, and cybersecurity. I have the pleasure of moderating this session with Hillary Wells and John Gray today, and I will give you some background on them. John Gray is the Of Counsel with Lewis, Rocha, Roth, Gerber, Christie, LLP in Phoenix, Arizona. He, as a certified information privacy professional, John advises clients on a variety of privacy and security matters. He has represented individuals and organizations in litigation across California as well as Arizona. Before joining Lewis Rocha, John served as the data privacy team leader for the Arizona Attorney General's office and as the co-chair of the Technology Futures subgroup for the Arizona Cybersecurity team. Ms. Hillary Wells is a partner and chair of the data protection and cybersecurity practice at the Denver office of Lewis Rocha, Roth, Gerber, Christie. She represents businesses including banks, financial advisors, private equity companies, insurance companies, and healthcare providers in assessing their legal obligations with respect to cybersecurity and compliance with data protection laws. And I think you'll find the session just fascinating. I just heard it for the first time, and it's pretty enlightening. So without further ado, John, I'll hand it over to you.
Perfect. Thank you, Yarrow, for that introduction. And I hope this second round will be as fascinating as the first round. We will certainly see. And to the extent that there is anybody I see in the chat that there might be somebody who's in the same room as last time, this is going to be the same presentation, so you probably don't want to be in the same room that you were last time. So you might want to log out or email Gretchen to see what you might need to do there. But in any event, we'll kick things forward here. We have entitled this presentation, Building Trust in a Digital World, Cybersecurity and the Rule of Law. So I always think it's helpful to define terms when we're discussing anything of this sort. So the first question, I think, is what do we mean by the rule of law? I think certainly most people have a general understanding of what we mean when we say the rule of law, but a more specific definition, I think, is going to be helpful in focusing our discussion for this second session today. So I've pulled from uscourts.gov here a definition which explains that the rule of law is a principle under which all persons, institutions, and entities are accountable to laws that are publicly promulgated, equally enforced, independently adjudicated, and consistent with international human rights principles. Now, that's a fairly legal definition from a fairly legal source. So I've also provided the Oxford English Dictionary definition here, which is a little bit broader or more general. And that definition is the authority and influence of law in society, especially when viewed as a constraint on individual and institutional behavior. Hence, the principle whereby all members of a society, including those in government, are considered equally subject to publicly disclosed legal codes and processes. Well, why is that important? The Stanford Encyclopedia of Philosophy says that in various ways, being ruled through law means that power is less arbitrary, more predictable, more impersonal, less peremptory, less coercive even, and it establishes an environment that is conducive to liberty. Aristotle is even more basic than that. He said that it is more proper that law should govern than any one of the citizens. What do we mean by that? Well, what we mean by that is that it is preferable to be governed by an equally applicable set of laws that everybody has to follow, as opposed to being ruled by a single individual who may create arbitrary laws or regulations at any point in time. And so what's my definition? This third definition here is just my thinking about the rule of law. So it's the John Gray rule of law. I think the rule of law is important because it builds impersonal trust. It allows strangers to interact with one another. Well, what do I mean? What I mean is that when I go down the street, I don't have to take an army with me to ensure that I'm not mugged or robbed. I can trust that the rule of law is going to apply to anyone out there who might want to do me harm. And I don't need to actually trust each and every individual that I meet along the way. I can trust that the rule of law is going to apply even if I don't trust any of those individuals that I meet, or any other individuals in society. So likewise, I think it's important to define cybersecurity because, again, I think we all know, generally speaking, what we're talking about when we say cybersecurity, but I've included a couple definitions here. The first one I like, and I've included from the Cybersecurity and Infrastructure Security Agency, or CISA, because CISA defines cybersecurity as an art. So some of you who practice cybersecurity may be interested to know that you are not practicing a science or a field of study, you are practicing an art, according to CISA. So CISA says that cybersecurity is the art of protecting networks, devices, and data from unauthorized access or criminal use, and the practice of ensuring confidentiality, integrity, and availability of information. Now that's kind of a mouthful, so I've also included the Cisco definition here, which is a little bit simpler. And Cisco says that cybersecurity is simply the practice of protecting systems, networks, and programs from digital attacks. Well, okay, why is that important? Again, I think that cybersecurity is important because it also builds impersonal trust. It allows strangers to interact online, very similarly to what the rule of law does in a general societal way. Cybersecurity does online. In the absence of cybersecurity, I really would have to know everything about the ISP that carries my data. I'd have to know everything about Amazon. I'd have to know everything about Google, because I would need to trust that those individuals or those companies or those entities are protecting my information. But when I understand that those companies are practicing cybersecurity, there are cybersecurity laws and regulations that govern certain aspects of those companies' businesses, I can begin to trust not the specific entities or every step along the way of my online interaction. Instead, I can just trust the environment. I can trust the cybersecurity environment that exists. Now, I don't think we're there yet. I don't think we can truly trust the cybersecurity environment at this point, but we're getting there, and hopefully we will get there eventually. And I think it's also important because our life is increasingly being lived online. And so cybersecurity becomes vital, not only to individual well-being, but societal well-being. Because as we've seen just in the last few months here in the United States, elections, a lot of that is being conducted online. Now, we don't get to click a button that says I vote for this presidential candidate or that presidential candidate. But even if I fill out a paper ballot, it may be tabulated electronically. The tabulated results may be sent electronically over the internet. There may be, other aspects of society as well beyond elections. Certainly, a lot of tax filings are made online. Business registrations are made online. A lot of societal functions are now online in a way that they weren't before. And so cybersecurity becomes increasingly important in that world. And so how do these two things intersect? How do cybersecurity and the rule of law intersect? And I will turn things over to Hillary to talk a little bit about that.
Thank you. As John said, the rule of law is what gives us really the structure and the regulations and the opportunity to have certain agreements unspoken about how cybersecurity is going to relate to our legal obligations. And so in this digital world, we'd have to have those two things come together. And what we see in the data protection and cybersecurity field from a legal perspective is there has been a amount of disconnect between where the laws lie and what they actually regulate versus the global economy we live in and the international structure in which we share information. And as John said, the amount and types of information that we now share online. And so, frankly, from a legal perspective, especially in the United States, the rule of law is playing a bit of a game of catch up. And what we'll talk about is how the US laws in particular have been siloed into industries as opposed to looking at the rule of law as something that needs to protect information, personal information in particular. And the different approaches that have been taken in the EU with the GDPR and how California has really weighed into this space of trying to reset the rule of law in the United States from the perspective of how we regulate different industries to how we protect personal information. And as the slide says, without cybersecurity, we wouldn't have a functional world. We wouldn't have the ability to function digitally with our courts and with our agencies. And I can personally speak to the past 9 months, having not appeared in a single court personally, but having participated in mediations and evidentiary hearings and depositions, all conducted in an environment that did not exist when I started practicing law. So if you go ahead and flip to the next slide, please. So as I said, let's talk about what the laws are and how it is that we are operating in a space where information in the United States is not protected, but instead industries are regulated. And so in the US, we've got a number of laws that are specific to industries, and frankly, they're relatively old laws, especially if you consider their age relative to the development of our online lives and the development of an industry that has yet to be regulated, that I think in our last group, we found to be one of the most interesting in this space. And in the United States, it's a space that's in a vacuum, and that's the industry of monetizing personal information. There is no rule of law in the United States around monetizing personal information across all industries. Instead, what we have is a series of laws intended to protect certain information when it is created or held by certain industries. So for example, when I speak to both lawyers and non-lawyers alike, there is a general perception that medical information is so personal that HIPAA must apply to it wherever it exists in our society. That medical information is something that should be subject to the security rule that speaks to the measures that must be taken in order to protect the information from a physical and digital standpoint, and the privacy aspects of that same information. Yet the rule of law doesn't look at medical information as something that is so private that across all industries, whomever has it, HIPAA will apply. In the United States, HIPAA applies to 3 categories of groups in the medical field. The first is a healthcare provider. So these are your doctors, dentists, chiropractors, those who are actually providing the medical service. The second is the healthcare plans. So these are the insurance companies and the providers of the financing, largely, for the medical services that are provided by the first category covered by HIPAA. And then the third is a healthcare clearinghouse. And the details of the third are not important. What is important is to say that your medical information has protections under HIPAA and is regulated under HIPAA when it is created by your medical provider, when it's transmitted by your medical provider to the payor, to the entity that needs to have the information in order to assess its payment obligations. But when it's transmitted to someone outside of that limited framework, it has no protection under HIPAA. HIPAA is going to cover the entities I described, which are legally defined as, quote, covered entities, and it spiders out to what are called business associates. And so these are the service providers who support that healthcare and payor industry. So for example, the lawyers providing legal advice to doctors assessing their obligations under HIPAA, and to the software vendors who are developing and building the software that hosts health information about individuals. But that's really the only place the medical information enjoys protection. When children's information is sent to the school on a medical side, it's not protected by HIPAA. The FERPA law that I'll speak to briefly in just a moment would protect private information at the school, but HIPAA does not. And so again, in the US, we've really focused, because of the way we regulate by industry, we have built a rule of law around the protection of private information in the industries, rather than recognizing, as the EU has, the fundamental privacy right of individuals and requiring businesses and commercial entities across all industries to provide protection. Another example of a law that is supposed to be a privacy law is the Gramm-Leach-Bliley Act. And unlike the healthcare provider law, which I would say is relatively narrow as far as its umbrella of protection, the GLBA is a very broad umbrella because of the definition of financial institutions. Financial institutions are defined really as any entity that engages in frequent financial transactions. So it's not just the banks, it's also insurers and insurance brokers. It is also those who are auto dealers who engage in financing activities on a regular basis. So from an umbrella perspective, this old law is good. Where it is less helpful is in what it covers. There's a security aspect of the rule that says the information collected must be protected, and that of course we expect. And then there's the privacy aspect. But the privacy aspect, I use the word privacy because that's the legally correct term, but the privacy rule is privacy in air quotes in my mind, because the rule doesn't require banks to do more than, or financial institutions to do more than disclose their privacy practices with respect to the sharing of information, personal information about customers to their affiliates and to non-affiliates. And so I suspect everyone who is sitting in this talk today once a year is receiving from Wells Fargo, Bank of America, something like this, a chart. And that chart that you promptly, I would gather, put in the round file if you receive it by mail still, or perhaps just delete when it comes in the email box, explains this is the information we collect. Do we share it with affiliates, yes or no? And can you stop the sharing? And then another category is we collect this information and we share it with non-affiliates, perhaps for marketing purposes. And can you stop the sharing, yes or no? With respect to the first example I gave where the information is shared with an affiliate, GLBA requires the financial institution to disclose the fact that it shares with affiliates. So if a insurance arm to the bank, that would be an affiliate, and it can say and it can share that information for marketing as long as the sharing to that affiliate for marketing is disclosed. What I think surprises people is you can't stop it. The disclosure is required, but there's no obligation and no ability for a customer to insist that the sharing does not occur. And the exception is with the non-affiliated entities. That type of sharing you can stop, but it's a little bit onerous. You have to take affirmative steps to exercise the right to opt out of having your information shared. And again, you don't have this kind of across the board, privacy protection. And so, we sit in a place, like I said, where from my perspective, one of the most important groups that would fall into a regulated field is every company in my mind that for a revenue source or a revenue stream monetizes personal information, that industry across the board doesn't have a federal regulation like HIPAA or GLBA, or as I briefly mentioned, FERPA for federally funded financial institutions. The state breach notification laws have, they align in some ways, they don't align in others. It's very difficult for a business to engage in business activities and to face a possible breach notification obligation because there are different states that have different requirements with respect to what, if anything, must be investigated, the nature of the disclosure, the timing of the disclosure, and whether or not you have to put out notice to, for example, states' attorney generals, and that's the office that of the Arizona Attorney Generals where John came from, whether or not you have to give notice to those types of groups as well. And so I think, the idea there is, of course, consumers need to know what happened and what information may have been exposed, opportunity to notify credit reporting agencies and told of that opportunity, and often offered the identity theft protection, insurance as it is, for a year. Honestly, I think people have gotten numb to these letters. I know I have. Last I read, it's only about 20% of people who receive a data breach notification that actually go ahead and trigger and ask for the identity theft protection. And so we're not, in the best space there. Again, we're disparate as far as the laws across the state, and the utility of those notifications, I personally call into question just because of the frequency of them. So then we get to California. California really dove in head first into privacy when a group of voters headed up by one in particular in Northern California became very concerned with how personal information is monetized, and look to, the GDPR, which had been recently enacted in the European Union, as kind of a model for what he viewed to be a reasonable structure and reasonable rights to afford California residents with respect to their personal information. And the CCPA does look in some ways like the GDPR. California resident is entitled under the CCPA to require a covered company, for-profit company, to itemize personal information that it has collected him or her in the past year. It is, or he or she rather, is allowed to indicate, do not sell my personal information, which is a bit of a mirror. Selling really includes any sort of third-party transmission of personal information. So that's a right, and it's got some structures around it, kind of like the business associates I described in connection with those who support the healthcare industry. And there's the right to delete, and that sounds like, well, I can just notify a company, I'd like you to have all my information purged. And while that right does exist, there are restraints around it because the business does need to be able to meet, for example, its regulatory obligations with respect to record keeping, if your information might be subject to a regulation concerning record keeping. And then also there's just the practical matter. A company can't receive an order to provide goods or services and then receive a request to delete without having the opportunity to use the information to fulfill the order for goods or services. And so it's going to be interesting to see how the CCPA, works itself out, because, it's how it applies is, still being worked out in this digital world where a lot of companies interact with California, but don't necessarily have a lot of contacts with California as far as a percentage of their business. And probably more importantly is the fact that the CCPA applies not only just to for-profit entities, but only to for-profit entities that have annual gross revenues of at least $25 million. And so there are a lot of companies that interact with California residents that we encourage to exist and to grow, small businesses, businesses who are founded by and run by persons of diverse backgrounds. And this law, because of that revenue threshold, doesn't reach them quite yet. I want to have John, if you would, speak a little bit to kind of the evolution of the CCPA, because it's come so quickly, and how it is trying to make that broad umbrella drop down far enough, perhaps, to capture more entities and to provide more protection.
Yeah, thank you. So I think you're exactly right, that the CCPA is trying to provide a larger umbrella to cover more data, more entities, and we're starting to see other states as well trying to build the rule of law into this space online. And the CCPA has evolved from a voter initiative originally to a legislative process, and then a law that was passed and signed. And now we have the CPRA, which is the second version or second iteration of CCPA that's just recently been passed at the most recent election by voter initiative. And so California is moving very, very quickly in trying to implement different obligations and parameters around the use of data, collection of data, and consumer rights with respect to that data. So I think, as you said, we're continuing to see the rule of law evolve in this space, and it's starting to take shape, but it's difficult. We're dealing with information. How do you regulate information? If I tell my birthday to a friend of mine, do I get to dictate when my friend tells other people what my birthday is? It's difficult. These are difficult questions with the CCPA, but other state data breach notification laws, and now laws in other jurisdictions, including the very recent LGBT in Brazil, trying to get a sense or trying to wrap our heads as a society around how to deal with some of these security and privacy issues. So I think you've done a great job covering CCPA in particular and some of these other laws as well.
And what I would say about GDPR is it's had a lot of very good press. I think it provided a framework, obviously, for the CCPA, but something I find interesting is really its history. EU and the member countries have recognized since really the 90s the right of an individual to privacy in a way that we haven't recognized it in the United States. The directives for the CCPA go back to the mid-90s, and they have grown up alongside with, but of course still behind technology. You know, a challenge, you know, with the rule of law is the more specifics you give around what is required and by whom, the easier it is for someone to figure out how to either get around that rule applying to it, him or her, or by prescribing specific technologies like encryption or something else. It can be that those prescriptions require technologies that become archaic and less efficient in delivering the security services that they are intended to provide. And so, as I said, with the GDPR, they've got a much longer history. They had a much more robust process in developing that law than the CCPA did. The CCPA came together very quickly. But a challenge we have in the United States is that the GDPR regulates not only the collection, processing, and security of personal information, but also the transfer of personal information internationally. And in the United States, we have not been recognized as a country that has adequate protections or adequate assurances for data protection. And so the law, the GDPR, does not permit companies to transfer information from the United States, or I'm sorry, from the EU to the United States. And what had been done a number of years ago is the FTC tried to build around this challenge of adequate assurances and put together a program called the Privacy Shield. And the Privacy Shield was a program that companies could subscribe to, they could pledge to and agree to be bound to, where they would agree to a framework and strictures around the information they process and the protections that would be afforded that information. And for a number of years, it seemed to work. It would allow US companies or companies operating in the US to lawfully transfer personal information from the EU to the United States. But this summer, there was a challenge against Facebook around this data transfer, and the European Justice Court announced a decision in late July declaring that the Privacy Shield framework was insufficient. And so in the United States, no longer have a go-to even voluntary regulatory scheme to allow a company to lawfully process in the United States information from personal information from citizens and residents of the EU. And so we're currently working with clients who are trying to, as best they can, comply with a law that doesn't allow them to do what they've been doing for years. And really, I view this as a political problem. And there's got to be a way for the rule of law to meet this challenge of the global economy, and to simply declare that the US, because of its information sharing practices, particularly with respect to law enforcement, that there's an issue that makes it impossible to share information. To me, that seems like a solution that cannot exist, or I'm sorry, problem that can't be left unchecked. And I do know that the FTC and various data protection authorities in Europe are working very diligently to come up with something that will allow us to continue to transfer information.
Okay, sorry, I had to unmute myself there. So I think this is a really good segue into the final slide here, and we'll open it up for questions. If anybody has any questions or comments, we'd love to see those in the chat, so feel free to start lobbing those in. But this last slide asks, how do we ensure cybersecurity and the rule of law in the future, and how do we build trust in a digital world? And I think Hillary's last point there, to some extent, addressed that. How do we build trust not only online generally, but across jurisdictions, particularly in jurisdictions where the rule of law may look different? The rule of law in the United States may look very different to the rule of law in other countries or in other cultures that view some of these issues differently. But I think two areas that can certainly help are new and better technologies and new and better laws. And particularly on the technology side, I think I'm more optimistic perhaps there than I am with respect to laws. But on the technology side, we have new and evolving technologies that are attempting to meet these challenges of cybersecurity and building trust and using not only the rule of law here in the United States, but the rule of law generally to say, how do we deal with these problems? And so we have the issue of trustless computing, which really, to me, is a bit of a misnomer. It really does build the same sorts of impersonal trust that the rule of law does, because you don't have to trust any individual actor in a trustless computing environment. You've got blockchain and distributed ledger, which have obviously been garnering a lot of attention lately. I'm not sure that those are necessarily going to ensure cybersecurity in the future, but nonetheless, entrepreneurs and other individuals out there are attempting to use these technologies to promote cybersecurity and better transmission of data in a safer way. Encryption, I think, is probably the biggest of technological advance, and it's also the biggest area in terms of how the rule of law is going to evolve in terms of addressing these technologies, because we have encryption technologies that are quite good at protecting data, but you may want, as a society, to limit the ability of companies to implement that encryption, or even individuals to implement that encryption, because you may want to have a back door, if you are law enforcement or the government, into devices or software or hardware used by criminals or alleged criminals. And particularly, we've seen this recently in connection with the San Bernardino attacks a few years ago, and trying to unlock the attacker's phone to determine whether there were other attackers working with that individual, trying to break or jailbreak the iPhone of that user. So there are a variety of issues surrounding ethics, the rule of law, in connection with some of these new technologies. And then, as Dr. King discussed this morning on the keynote address, we have machine learning that can do a lot in terms of advancing cybersecurity, but how do we apply the rule of law to that machine learning technology? And how do specific laws in various jurisdictions keep pace with the advances in? I think Dr. King addressed some of those. I'm not an expert in machine learning, but certainly there are a number of questions there from a legal perspective to say, okay, how do we deal with some of these issues? And it's going to continue to be difficult moving forward. It has been difficult thus far because the rule of law simply hasn't applied in the past to this digital world, which is a new world. And we're evolving, we're trying to get there. And I think the second category of new and better laws is talking about a lot of the things that Hillary talked about in terms of CCPA, CPRA, LGPD in Brazil, some of these new laws. How are they addressing these issues? I don't think more laws is necessarily always the answer, but better laws should be at least part of an answer. And I think part of that is having more consistency, particularly here in the US, because as Hillary said, we don't have a lot of consistency across jurisdictions between state and federal and across industries. And I also think better enforcement of existing laws and any new laws that might be passed would also help, because particularly here in our common law system, our rule of law evolves not only with legislative enactments, but it also evolves in the court system when we're talking about, has someone implemented quote unquote reasonable security under HIPAA or under GLBA or under FERPA. What do we mean by reasonable? And the more court decisions that you get, the more settlements that you get, the more we learn about what society, about what judges, about what juries think is reasonable and what is unreasonable. And so as we get better enforcement over time, we get better laws over time, and we get better technologies over time, hopefully we're building trust in this digital world and hopefully contributing to the rule of law applying to this digital world. But it remains a very difficult problem. And I think it will continue to remain a difficult problem for quite some time. Have there been any questions, Hillary? I don't know if I saw any come in. I know we had a very good, yeah, nothing yet. I was going to say, I know we had a very good question in the last session about why aren't the rights and privileges and obligations in something like the CCPA just the default? Why is that difficult to implement in a legal regime? And I think the answer to that has multiple parts. I think number one, it's difficult because it hasn't been the default, right? It hasn't been the default that computers have evolved, or computer technologies have evolved in a way that that has been the default. Quite the contrary, the default has been that I share my information with you via a computer, and you are entitled to do with that information whatever it is that you want, because it's information. It's like my birthday example earlier. If I share my birthday, or if I share a photo with a friend physically in person, that person, traditionally in our society anyway, has been free to go share that information or that photo with other people, or to go copy that photo. Now, laws have evolved on copyright and use of public rights and rights of publicity, but for the most part, information has been viewed as shareable by default. And so we're trying, as a society and as legislators and as regulators, people are trying to change that default regime to something that looks more like CCPA or more GDPR. But it's also difficult because those aren't necessarily the right solutions. You can view CCPA as very positive. You can view GDPR as very positive, but you can also view them as perhaps too broad, or perhaps too onerous on companies. It certainly, I think, regulations of that scope tend to favor larger actors, even as when Hillary said CCPA exempts certain smaller actors. Nonetheless, when you have a giant compliance regime that's very difficult to maintain, certainly that's going to favor larger entities. And so, in fact, what we saw with GDPR fairly early on, once GDPR came into effect, more advertisers, more people using Google services switched to Google because Google ensured that their products were GDPR compliant, as opposed to people switching away from Google, which is what some advocates of GDPR thought would happen, because they thought that Google was less privacy oriented than some of the alternative solutions that, you know, could have been spurred by competition. But in fact, what we saw is that those entities actually got all the requirements of GDPR. I think you're going to see something similar with CCPA over time as well. So it is difficult to implement these new legal regimes, and it's particularly difficult across jurisdictions because people view things differently. Obviously, here in the United States, we have a very different view of freedom of speech, freedom of transmission of information, which is really what speech is. It's the transmission of information. And other cultures don't necessarily share those views, and vice versa. Some cultures have very strict privacy regimes. Others tend not to view privacy in the same way that we do. So a lot of very difficult issues that I think are going to continue well into the future. I just got the notification on my screen that we have 5 minutes left. So if anybody has any questions, get them in now, because I know last time we were muted with a couple minutes to go and we weren't able to get to some of those last questions. But that's really all I have. Hillary, did you have anything else to add?
No, it's an interesting, place, the rule of law, and trying to get a framework in place that works with the wonderful technologies that we've had and enjoyed is a challenge that we all face.
Yeah, and we definitely appreciate everybody's participation here. This has been a really great conference, and we appreciate the opportunity to speak. I do understand that these presentations will be emailed to everybody via link, so if you're not able to participate in one of them that you wanted to see, you should be able to do that with a recorded link. But thank you again, we really appreciate it. And Yarrow, thanks to you for your technological help here.
John and Hillary, thank you so much. Yeah, it was definitely eye-opening. I wanted to ask what your guidance was on how we should venture into the online world, but I think with caution is probably the takeaway.
And very carefully.
Yes. Thank you both so much. Be well, everyone, and enjoy a lunch break and the rest of the afternoon session.